We will go on the record in the matters 25 CM 113, 25 CM 185, 25 CM 216, State of Wisconsin versus Lee Moritz. The state appears through Assistant District Attorney Jose Vila in person. Mr. Moritz appears in person. I just noticed your shiner.
Yeah.
What happened?
Had an accident at home. Fell off a ladder.
That looks pretty bad.
Yeah, it's not good. It doesn't feel good.
Ouch. So Mr. Moritz appears in person with his counsel, Joseph Rosenthal, by video conferencing. We're set for a plea and sentencing. Mr. Rosenthal, is this matter proceeding as such?
Yes, Your Honor. The defense is ready to proceed.
Okay. And Mr. Moritz, Mr. Rosenthal is appearing to your left on the video conferencing screen. At the last hearing, I believe you indicated and said that you are okay with him appearing by video.
Yes.
Do you understand? You do have the right to say, you know what, Judge, I want him to be seated next to me.
Does it really? Does it matter?
It doesn't matter to me.
No, we talked about this and saved us both time, you know. Why drive if we can do it by phone?
And money.
Right. Yes. Yes. Absolutely.
But it is your right to have him in person. So
right. No, we discussed this.
And I want to let you know that if at any time maybe you can't hear him or see something or you can't see him or hear something that he's saying, let me know. I need to make sure you've heard and you've understood everything that happens, okay?
Yes.
And if at any time you have any questions or concerns and you need to speak with your attorney, let me know. And either I will adjourn the hearing and let you go give him a telephone call, or I will adjourn the hearing and put you into our Zoom room and put you into a confidential breakout session with him, okay?
Yes.
All right. So, Mr. Rosenthal, what is the agreement that's been reached?
Your Honor, my client's going to plead to the sole count in 25 CM 113. The remaining two files would be dismissed and read in, and parties would be free to argue sentencing.
All right. Okay. Free to argue. I do have a plea questionnaire waiver of rights form. Mr. Rosenthal, you informed the court that you have filed it, but that it has not been signed yet, and you wanted the court to have that in front of Mr. Moritz. It was placed, it was placed on his table and by the clerk, and he has reviewed that. And Mr. Moritz, is that the document that your attorney went over with you, those two documents?
Yes.
And so you reviewed them thoroughly?
Yes.
And did you sign those documents?
Yes, I did.
Okay. Now, can you please bring those documents? Well, why don't we go through the plea questionnaire, plea first, so you have them in front of you while we go over them, and then you can file them with the clerk. Victims' rights compliance?
Yes, Your Honor.
Will victim be making a statement here today?
Yes, Your Honor.
All right. The victim can come up here to the black desk, table desk. You do not have to tell your name. If you want to, you may. Otherwise, you can say your initials, okay? So you can come up here.
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. What starts as a routine plea hearing is about to turn into a full courtroom reckoning. A defendant accused of violating a protective order is moments from hearing devastating allegations, while the judge watches every word, every reaction, and every excuse. This case isn't just about text messages anymore. It's about credibility, accountability, and whether the court believes this behavior was a mistake or a pattern. Stay locked in, because the tension is only building.
And it looks like you have something that you may be reading to the court. I am just going to ask you to please read it slowly and enunciate your words. And if it is going to get emotional, just stop and take a breath, just because our court reporter needs to take everything down. So when you can speak slowly and enunciate and breathe, she's able to take everything down accurately, okay? All right, you may be seated or you can stand, whatever you prefer.
I have a question.
Yes.
May I read this exactly how it was said to me or stated at the time? There's some crude words and comments in here.
Yes, I will allow you to do that. I know that those are things that may have been, don't take this wrong, but allegedly said to you.
Yes.
Yes, so you may, if it has vulgar language or swear words or things like that, you may say the entire word and not be in contempt of court. Okay? I'm going to also ask you to take the microphone and have it more towards you.
Is that better?
Yes. You may begin.
Your Honor, I have spent months thinking about this the day I would get to stand in front of you and speak. I have written pages of my life and incidents with Mr. Moritz, and there was one statement they all had in common. He knew exactly what he was doing. Mr. Moritz knew exactly what he was doing every time he violated the restraining order. He lied and manipulated situations to avoid responsibility. He twisted events and told false versions of what happened, but one thing remained consistent. He blamed everyone else. He knew from the beginning he had a restraining order. I told him I was getting a restraining order for trespassing on my grandmother's property and taking my car from me. After that, he texted me to drive the only thing in my name to work tomorrow, leaving me my gas golf cart. But he didn't seem to care because his response was, "Do whatever you have to do." I have thousands of text messages where he stated things I wrote in the petition, how he knew he had a warrant, and stated, "I asked you not to get the law involved." He avoided every court hearing. He would text me asking why cops were knocking at his door. He stated multiple times he didn't care about the restraining order. He ignored every police officer that told him to stop contacting me. He threatened me to drop the charges, telling me how small I am and what he can do when he's sober. He purposely avoided police for 8 months and continued to harass me. During this time, I felt unprotected by calling into the sheriff's department. The first time I called, the deputy that I got asked me, "Have you just tried blocking him?" And the text messages that I sent to the deputy never made it to the DA's office. The victim witness coordinator told me there was a possibility of closing the case due to the missing documentation of the text messages. Mr. Moritz also told me his sister, who is a police officer, notifies him every time I call him in, and that he is above the law because of this. Whether this statement is true or not, I do not know, but I can say that there was information Mr. Moritz and his sister both knew about when I spoke to other police officers and jailers. One of the times Mr. Moritz was brought into jail. Along with Mr. Moritz's blatant disregard of the law, he also has a terrible drinking problem. Mr. Moritz buys a case of beer every day or every other day, as he puts it, when they're good days. He states he uses his beer as a medicine when he refuses to take any mental health medicine or pain medicine. He also says his doctor told him drinking his beer was just as good for him as any other option. I would be surprised if he blew a .0 here today. If you notice on the text messages submitted and other documents, most of the time Mr. Moritz starts harassing, threatening, and abusing around 4 p.m. He's had then hours of drinking in, and depending on his schedule, there are times when he doesn't sleep and drinks all night long and makes the situation even scarier. These patterns of abuse happened while the children and I were both in the home. Mr. Moritz repeatedly abused me and the children. This was not an isolated incident. It happened in different ways and continued to escalate over time. Mr. Moritz used emotional and verbal abuse throughout our relationship. He often insulted me and humiliated me, especially about my body. He would tell me things like, "You're disgusting," and told me he would only listen to me or seek help for his drinking if I maintained a certain weight. He often called me worthless and a cunt, and I could be replaced at any time. These were things he said in front of the children, teaching them to be disrespectful to me too. This happened regularly, and after arguments, he would deny or say I was too sensitive and that I shouldn't take what he does or says after a night of drinking too seriously. Tomorrow's a new day and you need to move on from it. He emotionally abused me to control and scare me. After my mother died of lung cancer, he taunted me about my smoking and told me to go kill yourself and smoke another cigarette like your mom. He told me I had no family left that cared about me and no one else would want me, so I'd better stay with him or I'd be alone. He also told me in front of my son that it would only take $10,000 to have me killed. These threats and cruel statements happened many times over the years. Mr. Moritz would also abuse the children. He'd call them names like stupid, bitch, fucking pussy, retarded bitch, pervert, fat ass, and blame them for problems in his life. There were physical incidents that happened, including throwing wood at his son and grabbing him by the throat. This behavior led to a CPS case in 2023, and instead of taking responsibility, he blamed me and the children. After my son was interviewed as part of the CPS investigation, Mr. Moritz threatened my son for telling the truth to CPS, stating, "I should choke you like you said I did to my son. Do you know how long it takes someone to turn blue?" Physical abuse was also a repeated pattern for me. He forced me out of our home on dozens of occasions, dragged me out of bed, locking me outside with no place to go. One time he dragged me out of the house by my ankles and locked me out. But then he called me the next morning when I wasn't home, asking me when I was coming home because he was horny. Another time he threw a tray of grease and fat at me and my son when we tried leaving, hitting us in the car. He's had his hands around my neck, pinned me in corners, threw my phone in the toilet and peed on it so I couldn't contact anyone. And at these times I had to fight back to protect myself. When I did fight back, Mr. Moritz would tell me would tell people, family and friends, he didn't do anything, and I just went crazy on him for no reason. When I was able to leave and get away from him, he would follow me in vehicles. He would show up where I was, follow me to stores and my family's homes. The times I could not leave were because he would hide my keys or even drive my car into deep snow so I couldn't move it. This behavior also happened multiple times and made both me and my child feel unsafe. Financially, Mr. Moritz has abused me by taking my car from me without permission, leaving me without a vehicle and no other access to the vehicles in both of our names. He told me I didn't pay for shit during our relationship and I didn't deserve anything, which is not the case. He continues to exert control over my financial abilities. He refused to work with my attorney to remove me from shared loans. While my attorney was retained, Mr. Moritz tried to impersonate me on the phone with her, refused to talk to the investigator my attorney hired to contact Mr. Moritz after this incident. I have a declaration from the investigator stating, "I'm not signing a fucking thing. If the house sells, she gets half." He has now allowed shared property to go into foreclosure and repossession, which has prevented me from being able to move on and purchase a stable home for my child. He has lied to the court and refused to cooperate with the legal process. One example of this is his repeated attempt to manipulate by claiming I had tax documents he needed. Upon hiring his attorney to help him gain the documents I was supposedly keeping from him, his attorney never sent me any requests for these documents, even though it was stated in court that there would be a letter sent to me that would be added under the criminal case. I do not have any legal documents. Mr. Moritz could not obtain copies of himself. The documents I have are mortgage loan documents and our 2024 F-250 loan documents, both in my name. Mr. Moritz also tried to buy propane under my credit card in January 2026. When I called and asked Northwoods Propane about the incident, she immediately apologized and said, "I'm so sorry, this is a card he said it was okay to charge to, but I'm returning your money immediately." This might be Mr. Moritz's first time with charges, but he is not a first-time offender. Mr. Moritz has multiple CPS cases from his children, a couple of closed cases with his adult children, one closed case with my son in 2021, the latest one with his youngest son and him being removed from our home immediately in October 2023, along with CPS being called again in November 2023 when Mr. Moritz threatened my son. Mr. Moritz refused to do anything to cooperate. In the most recent CPS case, he did not go to court. He did not go to any meetings. and he refuses to do anything to regain visitation with his son to this day, but continues to harass his son's mom, Terry Moritz, in the situation and blame everyone else for his shortcomings. Also stating to me he would rather pretend his son is dead than do anything to fix the situation. There are also 3 cases where Terry Moritz had to call the cops on Mr. Moritz for multiple reasons, including harassment, a safety check on his youngest child, and domestic abuse harassment, which he wasn't charged. I would go even further to call him dangerous. He knows exactly how to act, in front of who and when. His thought process and how he believes and perceives the world is scary. He told me more than once that I deserved my abuse, and the only reason I can get him in trouble for what he does is because I have a vagina. His children deserve their abuse. But he did not refer to it as abuse when he was speaking about me and his children. In his mind, he was defending himself, proving a point, or his actions were just everyday life. He always states he never does anything wrong. Mr. Moritz once told me he was like a god and should be treated as such. And I should be washing with his feet with my hair like Jesus instead of running my fucking mouth. He also told me once he was born in the wrong generation. He should have been born back when it was acceptable to lock up your wives for disobeying. Since I moved from his home more than once, Mr. Moritz has tried to portray on social media and in text messages that I have been with him. He will post pictures on Facebook and send me random text messages stating, "If you're still here, will you feed the dog?" I asked him to get help multiple times for his mental health and alcoholism. He believes he does not need help. He likes who he is. I watched him walk into this courtroom via video multiple times and lie to the court. The extent of his disregard for the law in this case, continuing to treat Mr. Moritz as a first-time offender when he is not, has only strengthened his belief that he is above the law and that his actions and legal violations carry no consequence. I fear that this setting is setting a dangerous precedent that will escalate his behavior for even further in the future. He has shown that he does not respect the law, the courts, or law enforcement and believes he can avoid all consequences. Mr. Moritz will not stop on his own. His ex-wife, Terry, who I've referred to multiple times in this statement, has not been in a relationship with Mr. Moritz for 7 years, yet he continues to harass her in different ways. There has to come a time when my child and I can stop walking on eggshells and looking over our shoulder every time we leave the front door of our home. For the safety of myself, my child, and others, I ask the courts today to see the bigger picture of Mr. Moritz's past and current actions, holding him accountable with consequences stronger than monetary. I would like to request 60 days upfront jail time and 1 year of probation. Thank you for your time and consideration.
And just so I have all the facts in my head. Well, Mr. Moritz, do you share a child with BJR?
No.
No. Okay. So
I raised her son since he
okay,
was 5.
so I just wanted to make sure. I just wanted to see that. Okay.
His father's Bert Barnes.
Okay, so I have in front of me that plea questionnaire waiver of rights form. Do you have that? That's that document in front of you, Mr. Moritz?
Yes.
And is that the document your attorney went over with you?
Yes.
Did he go over it thoroughly with you?
Well, as much as I can understand. It's all gibberish to me.
Well, as much as you can understand. So did and I'm going to guess that you had questions for your attorney and you said, I don't understand that. When you said those things, did your attorney then explain it to you more?
He did, but
And
in my mind,
Mr. Moritz, I'm stopping this. I'm not going to let you make statements and say, I don't understand this. I don't understand this. I don't understand this. Because if you're telling me that, then I'm going to have to order a competency evaluation, okay? Because I need to make sure that you're competent to enter a plea. You're competent to be here today and to have these charges brought against you. And so if I'm hearing from you that even though you're a learned attorney who's went to law school, who's practiced for many years now, if I'm hearing that he was unable to explain the words on that document to you thoroughly so you can understand,
He did, yes.
he did.
Yes.
So there's no question, you understand everything on that
Yes.
document.
Yes.
Okay, and so with that, everything on that document, your attorney essentially read that to you word for word, is that
Yes.
correct?
Yes.
And so you are telling the court that even if you didn't understand something at one time while he was going over it with you, you asked him the questions until you fully understood everything on this document.
Yes.
Now, coming to court here today, that document as well as the post-conviction document and whether or not you wish to appeal was placed in front of you on that table, correct?
Yes.
And you had an opportunity to review and read that thoroughly, correct?
Yes.
And you can read, write, and you understand the English language.
Yes.
Now, how many years of schooling do you have? Do you have an HSED, GED?
I graduated high school and I went 2 years to Dakota County Technical College for mechanics and machining.
Excellent. Okay, so you have more than just a high school education.
Yes.
Okay, so you can read, write, you understand the English language, so you understand this document and you reviewed it and read it thoroughly again when you got here to court.
Yes.
And then did you sign those documents?
Yes, I did.
So you are 50 and you are pleading guilty to one count of knowingly violating a domestic abuse order, correct?
Yes.
And you are not receiving treatment for mental illness or disorder, no AODA services or anything, because those kind of count as that. You've not had any drugs, alcohol, or medications within the last 24 hours.
No.
You have not?
No.
Zero. 24 hours. All right. Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Did your attorney thoroughly go over with you the maximum possible penalties you face?
Yes.
And so you understood those when he went over that?
Yes.
Now, because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on that first page in the middle of that document. It's bold and says constitutional rights underlined.
Yes.
Okay?
Okay.
Now, do you understand that by entering a guilty plea, you're waiving and giving up those rights?
Yes.
Do you understand you'll no longer have the right to a trial? You'll no longer have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You will no longer have the right to testify or remain silent and not have your silence used against you. You will no longer have the right to a jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty, and you will no longer have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights?
Yes.
And you understand you're giving those up?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Right. Yes.
Do you understand the state would have to prove as to count 1 in 25 CM 113, knowingly violating a domestic abuse injunction that on or around June 13, 2025, in Burnett County, Wisconsin, you knowingly violated an injunction in Burnett County case number 24 CV 120. Do you understand what the state would have to prove? They would have to prove that there is a domestic abuse injunction, right? First thing, right? You understand that?
Yes.
And they would have to prove that you violated that injunction somehow, and here having contact with the petitioner, correct? Yes?
Yes.
And they would also have to prove that you knowingly did so, meaning that you knew there was an injunction and you knew you weren't supposed to contact her, correct?
Not the first few times, but I did contact her after I didn't realize texting was illegal, to be honest, but
It's a contact. It's a form of communication.
I didn't understand
But
that.
here's the thing. I'm not asking if you did it right now.
Right.
And having you tell me when you did, when you didn't,
Right.
what you understood and what you didn't understand, okay? What I'm asking is, do you understand what the state would have to prove in front of a jury or to the court to find your guilt? Yes. All right. Do you understand the maximum possible penalty for this crime could be a fine of no more than $10,000 or imprisonment of no more than 9 months or both? Do you understand that?
Yes.
Now, do you understand that there's an agreement here And please recite it again, Mr. Rosenthal. I just want to make sure he understands it, the court understands it, we all understand it.
Your Honor, both parties are going to be free to argue sentencing. I will address those arguments when we get to it.
All right. So it's a free to argue. So you understand that?
Yes.
And so I guess it's not probation, it's not jail, it's not any of these things. It's a free to argue. And you understand that?
Yes.
And I'm guessing that's because of the negotiation back and forth, because one of the offers was to plead to 2 counts and all these things. And your attorney wheeled and dealed and negotiated on your behalf. And this is the end result. You understand?
Yes.
And you were working with him on the sidelines, telling him things, and he was telling you things, right?
Yes, ma'am.
All during this negotiation process.
Yes.
Okay. And so you understand that offer. Do you understand in the agreement that you reached? Do you understand I'm not bound to follow anything that is argued or recommended by the state?
Yes.
I'm not bound to follow anything that's argued or recommended by your attorney. You understand that?
Yes.
I am free to sentence you in what I feel in my discretion based upon all of the facts of not only this case, but the other cases, because they're being asked to be dismissed and read in. Do you understand that?
Yes.
So that means if I feel in my discretion based upon the totality of the circumstances, looking at you, looking at the cases, looking at the facts, that it should be the maximum possible penalty, that's my discretion and I can sentence you to that. You understand?
Yes.
Do you still wish to proceed and enter a guilty plea?
I have to talk to. Yes or no?
No.
Well, I mean, we talked
Do you
about
have
this
a
pretty
question?
thoroughly.
You went over it pretty thoroughly with him?
Yes.
We did. We had a number of discussions. I mean, this was the intent walking in here to plead guilty to this. I mean, I hope you've ever understood everything here, Lee, but I mean, this is kind of was explained in great detail. I mean, if you want to withdraw your plea, I guess now is the time, but I was under the impression that we had an agreement.
Your Honor, I am guilty from text messaging. That's
All right.
it.
And so that's
I
what you're
admit,
saying.
yeah.
You're admitting your guilt.
I did. There's proof.
All right. Okay. And so you understand the agreement and you understand that the court's not bound to follow anyone's recommendation. You understand that?
Yes.
And so you wish to proceed and enter a guilty plea today.
Yes.
Now, did you go over the facts of the criminal complaint with your attorney? And those are the facts on that original charging document that basically say what happened and why you were charged with these crimes. You remember that?
Yes.
Now, for the most part, as it relates to the charge you're pleading guilty to, those text messages, that communication and violating the injunction 24 CV 120, are those facts accurate?
Yes.
Mr. Rosenthal, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Are you admitting guilt here today, Mr. Moritz, because you are guilty?
For text messaging, yes.
Yes. I mean, you can try and pass it off any way you wish and try
Yes.
and, you know,
For
pass the buck, but it's,
No, I didn't understand that no contact I thought was physical contact. I didn't understand that text messaging was
all right.
out the window.
And here's the deal, and I'll swing right around to there, because I want to make sure you understand everything, because that's my job, is to make sure you understand everything. You're voluntarily, knowingly, and understandingly, intelligently entering this plea. Now, in the 24 CV 120 case, BJR versus Lee Moritz, and that was filed September 19, 2024, with a temporary injunction restraining order granted. Now, and a hearing was scheduled, and there were arguments made on the record that you were evading service and that they tried all means of service, and they had to resort to publication, okay? And so it was published in the Burnett County Sentinel, because you live here in Burnett County, and actually you're from the Sentinel area where they publish. And it had notice of that hearing, and you did not appear, but there was the proof of publication and you appeared. And so that injunction with the firearms was entered, correct? Yes.
Yes.
And so then a firearm surrender hearing was then scheduled, because the court is mandated to do that. And then service was attempted to be made with that, but then it needed to be published again. You understand that at that hearing too, you failed to appear, correct?
Correct.
And then the court had to issue a warrant because that is mandatory. The court shall hold a firearm surrender hearing, and you didn't appear, so the court had to issue a warrant, and a warrant was issued. You were picked up on that warrant on May 27, 2025. The court then held that firearm surrender hearing, correct? And you were present.
Yes.
And the court went over all of those things with you, all of the, with regards to the injunction, and you did make and raise arguments at that date and time that you didn't understand, you didn't know you needed to appear, and you didn't know what it meant to have an injunction, correct?
Correct.
And did the court thoroughly go over with you what that all meant?
Yes.
And so then you fully understood what it meant on May 27, 2025, correct?
Correct.
And so then you fully understood all of those things on May 27, 2025, is that correct?
Yes.
And this allegation in 25 CM 113, the offense date is June 13, 2025, correct? That's what I just went over with you, right?
Yes.
And so that date is after the May 27, 2025 hearing, correct?
Correct.
And so the court thoroughly went over what you can and cannot do and what it meant, correct?
Correct.
And then what happened occurred on June 13, 2025 after that, correct?
Correct.
All right. So I just wanted to make sure we were all clear. So now, with regards to that, you are pleading guilty because you're guilty, correct?
Correct.
Mr. Rosenthal, again, may the court use that probable cause section along with the statements now made and all of the A, B, C, D, E connecting with Mr. Moritz to find a factual basis.
Yes, Your Honor.
Mr. Moritz, has anyone made any threats or any promises to you for you to plead guilty today?
No.
You're doing so freely and intelligently. That means you're fully 100% telling me you thoroughly understand what's happening
Yes.
and why it's happening
Yes.
and the basis for why it's happening.
Yes.
And you're entering this plea voluntarily.
Yes.
Has your attorney represented you competently? Has he
For
looked
the
at?
most part.
For the most part, okay. So for the most part, he's represented you competently, correct?
Yes. Yep.
Has he looked at this matter thoroughly?
I believe so. I believe so.
And he's discussed things with you legally?
Yes.
And he received the discovery, the evidence in the case, correct?
He did read some of the text messages and we discussed it. Yes.
So he went over that evidence with you.
Yes.
And he went over options with you on whether or not you have any defenses, correct?
Right.
And
Correct.
whether you have no defenses, correct?
Correct.
And what would or could happen if this matter, these matters went to the jury, correct?
Correct.
All right, so he went over all of those things with you, correct?
Yes.
And you informed him of all the information that you know to exist as it relates to these incidents, correct?
Correct.
And you informed him of anything, of any defenses that you think may have existed, correct?
Correct.
Perhaps that you thought you could have texted, you didn't know that that was communication, those kind of things, correct?
Correct. Absolutely.
And when you went over your thoughts of defenses and what you believe to be true or not true, you discussed that with your attorney, correct?
Correct.
And he discussed with you the legal basis and whether or not your defense, your claim of a defense is really a legal defense, correct?
Correct.
And so he thoroughly went over all of this information with you.
Yes.
All right. And so at this time, with the result that you have and knowing that it's your choice to go to a jury or not, you chose to enter a guilty plea to one of these counts, correct?
Correct.
Now, knowing that your attorney did all of these things, for the most part, are you satisfied with his services?
Yes.
All right. Okay. Do you have any questions for the court or your attorney before I proceed?
No.
You understand everything?
As much as I can. Yes.
I can't know.
Yes.
So I need to know if you are understanding everything.
Yes.
Yes, you are understanding everything.
Yes.
All right. Then as to count one in 25 CM 113, knowingly violating a domestic abuse order, how do you wish to plead?
And there it is. The guilty plea is officially entered. That means the fight now shifts from guilt to punishment. This next phase is critical because sentencing allows the judge to weigh not only the charge itself, but the defendant's attitude, prior behavior, victim impact, and whether remorse appears genuine. Watch closely here. Sometimes what a defendant says after pleading guilty can help them, and sometimes it can make things far worse. Who do you think the judge believes at this point? The victim, the defense, or neither side completely?
Domestic abuse.
It's the charge, knowingly violating that injunction.
Texting, yes. The texting, yes.
Yes. Yeah. Yeah. So knowing that there was that injunction in place.
That just sounds really bad, domestic abuse, because I've never abused anybody. But
And
I did text, yes.
You
I
can
did.
argue those things, but the thing is what was entered for that injunction is a domestic abuse injunction.
Yes.
Okay. And you knew
Okay.
that, right?
Yeah, I understand now. Yes.
Yes. And we went over that back on May 27, 2025, right?
Yes.
Yes. And so now the charge here is that you knowingly violated that injunction order. You understand?
Yes.
And so as to that charge, knowingly violating a domestic abuse injunction order, how do you wish to plead?
Guilty for texting.
Well, you can put the caveat on all you want. I believe you fully and thoroughly understand everything,
I
correct?
understand. Correct.
So now as to that charge, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I will find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of this charge. The other two cases will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Vila.
Thank you, Your Honor. First and foremost, I would like to thank the victim for coming forward and providing her statement here today. Now, the state is arguing for a withheld sentence in favor of 1 year probation in this, 1 year probation in this matter. This is not a case of a single restraining order violation. Mr. Morris was charged with 3 counts of violating a domestic abuse injunction and 1 count of misdemeanor witness intimidation. Now, while he is taking some responsibility.
I'm going to say slow down.
Yes, Your Honor.
This is a long hearing, a lot of stuff. Slow down and
Yes, Your Honor. Now, while he is taking some responsibility by taking the plea here today, he also appeared before this court back on October 13th of last year and argued that he didn't understand the law. He didn't know what it meant to have a domestic abuse injunction in effect. And despite staying, despite saying in court that he didn't understand, one of the bases for the charges is that back in June of 2025, he texted the victim. He said he knew that there was an injunction in place. He knew it meant no contact and that he didn't care. So while he has no criminal history, I believe probation for 1 year is not only appropriate, but necessary to ensure that he does not have contact with the victim. To provide the victim with that added peace of mind, in essence, to specifically deter Mr. Lee Moritz from re-engaging in these problematic behaviors that have led him to this point.
I'm stopping
today.
you right here because you're going to, with what I have a question I need to ask Mr. Moritz before, because you're going to get an opportunity to provide any argument after that. I just need, because I need to know all the facts and I don't know what Mr. Rosenthal is going to be answering or doing these things. But Mr. Moritz, do you have a traumatic brain injury?
No.
Okay, so you weren't in an accident, didn't hit your head, don't have a traumatic brain injury.
Well, I bumped my head, but
Bumps, yeah. No, were you diagnosed by a medical doctor?
No.
For a traumatic brain injury? Okay. Learning disabilities?
No.
Okay, I just needed to know that. So I guess there's nothing you need to respond to. Go ahead.
Yes, Your Honor. So again, to specifically deter Mr. Moritz from re-engaging in these problematic behaviors in the future, but also to just generally deter the public that restraining order violations are criminal offenses. They carry penalties and they should be treated accordingly. I think ordering anything less would unduly depreciate the offense and send a negative message to the community that legal protections,
Yeah, you need to just.
So legal protections associated with having a restraining order, in a sense, wouldn't mean anything. So as such, I think 1 year probation is necessary in this case. Thank you.
All right, Mr. Rosenthal.
Thank you, Your Honor. My client has entered a plea here today. I believe he's done so knowingly, willingly, and voluntarily. He does accept responsibility after a very thorough plea colloquy with Your Honor. He's 50 years old. He does not have any sort of prior record. He owns his own landscaping business. He's a hardworking, productive member of society. I think that reflects well on his character. I will note that there have not been any incidents of contact that I know of since September. He's been following the injunction over the last 7 months. I think that does show that he is able to conform his conduct to the requirements of the law. In reviewing these texts, they're in large part pleas to get back together with the victim here. It was a bad breakup after long or 6-year marriage where, essentially he was pleading with her to come back. That's a large part of the text. There's no allegations here of any violence. There's no in-person contact with the text. There's no attempt to get a third party involved to circumvent the court order. I think the court can consider that as possible mitigating information. I know there's 3 cases and that possibly, is an argument for that to be aggravated, but I think the texts themselves and some of the other circumstances that I mentioned do go to mitigation. To his credit, he was very cooperative with law enforcement during the arrest. I think his sister, Bridget Getz, has already been mentioned. She's a law enforcement officer in Burnett County. I believe she's in the courtroom for support. As far as the probation argument, I generally, Your Honor, tend to think of probation as really addressing rehabilitative needs or public protection. I don't know that those are really relevant here, at least as to the charges pled. I know there's been a lot of allegations that were made in court, but he doesn't have a record. There's nothing as far as domestic violence that probation might address. There's nothing as far as AODA issues. There's a lot of allegations, but there's nothing in the record really to support that he has those rehabilitative needs that would necessitate some sort of supervision. I think, Your Honor, as far as addressing all the factors, his lack of record, some of the mitigation, as well as the fact that he's been on good behavior lately. We do not have a problem if the court wants to hit my client in the pocketbook with a $250 fine to serve as deterrence, but that's what we would ask for along with court costs. Thank you. That's all I have.
All right, Mr. Rosenthal, before I turn to Mr. Moritz, I want to make sure that you as his counsel, you've been there throughout these matters with him. Do you believe he has entered a plea freely, knowingly, and voluntarily?
I do, Your Honor, and I understood some of the court's questions about the competency and the brain injuries and those sorts of issues. And I do believe my client was able to assist and aid in his own defense. I think he understood. He's objecting to probation, so he clearly understands how that works. He was able to provide me details of the case. He knows what Your Honor's role is. He knows what my role is. He knows what the DA's role is. I do think that I am satisfied. I've been doing this a while. I've raised competency issues on a number of other occasions. I don't see those here.
All right. And you as his counsel, I don't want any specifics as to any discussions or anything that you've had with him, but you thoroughly went over the facts and allegations of these cases with him?
Yes, Your Honor.
And you thoroughly went over what the state would need to prove their guilt beyond a reasonable doubt?
Yes, Your Honor. And
you thoroughly went over the maximum possible penalties that he faces?
I did. We discussed the maximum potential penalties.
And again, you just to reiterate what you just said, you went over the fact that it's the judge's discretion in what is sentenced? I
did inform him that, yes, Your Honor.
All right. And then you also went over with him his constitutional rights and you believe he understands the rights that he will be losing after he just entered his plea?
We did review his constitutional rights.
All right. So you're satisfied that he has entered a plea freely, knowingly, and voluntarily?
Yes, Your Honor.
All right. Thank you. Mr. Moritz, I'm going to give you an opportunity. And now this is your time to tell me what you want me to know and what you want me to hear and what you believe transpired. And if you think that anything was stated incorrectly, to tell me the correct things.
I made a mistake. I love that woman, and I just was trying to get things worked out. I made a mistake. I didn't realize the repercussions of texting would go this far. I was just trying to work together so we could figure out our future. I made a mistake. I don't know what else to say.
Okay, anything else? That's all?
Well, a lot of half truths going on here, half truths, but I made a mistake. I did text and I apologize, and I don't know what else to say. There's proof. I mean, I did it. I was just trying to work things out for everybody. Just trying to make peace.
And this is your opportunity. And I know we are already over the lunch hour. This was not supposed to take this long, but I don't quit when it's your time right now. And it's the time for this case. And so if you think there are half truths and you want to let me know what those half truths are from your perspective, I'm here to listen, because this is where I make my decision as to what is going to be sentenced.
Well, Bobby Joe
Lee,
was very abusive to me.
I don't know that I want to get into litigating too much of this, Lee. I mean, but Judge is right. I mean, this is your time to talk.
I've been punched and beaten and scratched and scarred from that woman. And I didn't call CPS or call the police because I didn't want her to lose her son's custody.
Is that where you got the shiner?
No, this is a different, I mean, this is a couple of years ago.
Okay.
She beat me with an extension cord on my back until I was bleeding and bruised. That's why I locked her outside of the house, because she was violent tendencies. And it was so bad that I couldn't even take my shirt off on the boat for the 4th of July weekend because I didn't want my parents to ask what happened to your back. And there's a lot more examples to that, but I don't want to get there. I don't want to get anybody in trouble. I want peace. That's all I want is peace. That's just one incident, just one. There's many, many more.
Okay.
And she's playing the victim here, and it's half truths. You know, we're both human. It is what it is, but never beat her with an extension cord.
Anything else you want me to know?
I'm at your mercy. I'm at your mercy.
All right. Okay. Now, when a judge sentences an individual, this is your first sentencing in front of a court. You've been in front of the court for other matters, other things, but this is your first criminal sentencing. All right. A judge must look at certain things. First, the nature and the gravity of the offense. How serious is this matter? Second, the court must look at you as the defendant, your character, your past criminal record, any credibility, your age, your intelligence, your education, any of those things, okay, they come into play. Third, the court has to look at the public, protecting the public. And here, not really the public in general, but here the public when we have a victim involved. I think it's BJR or BR involved. So the court has to look at that. Plus, the court also has to look at other things, such as deterrence, general deterrence, to make sure that generally the public understands that they cannot violate domestic abuse injunction or any type of injunction whatsoever. It's a crime. Second, specific deterrence, specifically deterring you from committing this crime again or crimes like it, or any crime for that matter, okay? A specific deterrence. Now, I have heard the arguments of the state and I've heard the arguments of the defense. I've heard the victim impact statement. I've heard your statements. And so you know that the reason I have the victim go first in making the statement, some courts do it opposite. They wait until the plea and then they hear arguments from counsel and then they hear your statement and then they hear the victim statement. I have the victim go first because then it gives an opportunity for the attorneys as well as you to be able to digest what is being said. Mm-hmm. victim statements are like any other statements of any witness or any individual appearing in front of the court, okay? The court makes a credibility determination based upon what's said. Is what is being said credible? Are all statements being credible? Are any statements credible? I make that determination with each and every person that is making a statement to this court. That's my job, okay? To weigh the facts and to hear the case and to hear your basis, or to hear if you have any remorse and any accountability and accepting responsibility, those kinds of things. All right. And so again, the victim made a statement. Now, do I believe every single statement is 100% accurate? Probably not. But that's because I'm going to tell you, just knowing that sometimes as a person that's going through something, we experience something one way, another person experiences it another way, the officers experience it a different way. So any statement or any story somebody gives you is not 100% accurate.
Correct.
Okay? Yes, and you agree with that?
Yes, absolutely.
All right. So I've heard these things from everybody and heard the arguments and the bases for them. Now, and I'm looking at this matter in this case, and 25 CM 113, knowingly violating a domestic abuse injunction order. I thoroughly went over all of the things with you because I needed to make sure that you fully understand everything, that you understood that the injunction was in place, you understood at what date and time the injunction was entered, and what date and time you understood what you can or cannot do and why, and those things. And that was established back to May 27, 2025. And the first incident occurred June 13, 2025. In the violation. And you're saying the text messages, and at that time you didn't know or understand that you couldn't text, even though the court went over and said, I went over the no contact and it meant no contact on May 27th.
Yes.
Okay. And then we have another incident that then occurred after that on May 2nd, 2025. That was dismissed and read in, but the court can still look at that. Okay. And then another one on September, or did I say May? I meant September 2nd, 2025. And then another allegation of not only knowingly violating the injunction, but intimidating victim, dissuading reporting on September 15, 2025. Those again are dismissed and read in, but those are things, as your attorney went over with you, that dismissed and read in is something that the court can look at. That's part of the plea deal, part of the bargain. I'm not going to have to be found guilty of those by a jury or a court. I'm not going to have to plead guilty to those, but the court can view those and look at those in sentencing determinations. All right. So I know that you knew things and you knew what you could or could not do. You knew what it meant. You knew all of those things on May 27, 2025. And then we have the first allegation, the one you pled to, on June 13, 2025. And then a couple more thereafter. So I knew you knew what you could or could not do. And you're shaking your head up and down and saying yes.
Yes.
You knew. All right.
I knew after the first court hearing that I was not allowed to text.
Right.
And I have not since.
Well, you haven't since at least September 15, 2025.
Yes.
So throughout this process and throughout the hearings, before you had an attorney, after you had an attorney, even today, you've made statements and you've made things about, well, I didn't, to the best that I can comprehend, or I don't fully understand, or those kind of things. And that's why I had to question you the way I did.
Yes.
Right. And you understand why.
Yes.
Because I have to understand that you fully understand. I have to know you fully understand what's happening and when it all occurred, correct?
Yes.
And what you can and cannot do and when. You may have made those statements, and you've made those statements in multiple other hearings in different ways, in different shapes, and different forms. And it was mentioned by somebody here at the hearing, or by the victim, and it was mentioned previously at a hearing. And to this court's knowledge, your sister is a law enforcement officer, respected, experienced law enforcement officer.
Yes.
I respect your sister.
I do too. Very
Okay.
much.
I just want to put that out there. But again, I go back to this credibility thing. All right. I have to gauge credibility. I don't believe that you don't understand. I truly believe you fully understand everything and that you have understood everything.
I do know, yes.
Yes, but I believe you understood prior to today and prior to the last hearing and prior to the other hearing.
Yes.
Yes, yes. I believe you fully understood everything. I'm going to tell you that you sit there not only in this hearing, but in other hearings, and you put on a dumb face. And the dumb, yep, and the dumb
I'm not a lawyer.
words.
I'm not a lawyer. I have never been in trouble with the law. I don't.
Again, not an excuse, and you're saying words to make you seem like, I don't know, I'm just poor little old me. I don't know anything. I have a high school education and only 2 years of college with a very smart degree of mechanics, because I know plenty of mechanics. That's a smart degree. You need to be smart.
Right.
Right. You need to be smart. You are not a dumb man.
No, I'm not. I'm very intelligent, but when it comes to this stuff, it's
Again, credibility. I don't
no.
believe you. Okay?
Yeah,
You don't have a TBI, a traumatic brain injury. You don't have a learning disability. You don't have issues that interfere with your ability to comprehend or understand. You're telling the court you're not on any prescription drugs. You have not had any alcohol. There's nothing, no mental illnesses or disorders, nothing that is interfering with at any time your ability to understand and comprehend. And again, you're shaking your head up and down. Yes. Yes. That's the frustrating part, because you did know and understand and comprehend, and you knew so at least at the bare minimum all the way up to May 27, 2025.
Yes, Your Honor.
Yes.
I was trying to make peace. That's all I was trying to do.
Yeah, trying to make peace, violating the law.
Yes.
Right? Yeah, trying to make peace, violating the law.
Yes. Yes.
And today is your day for remorse, and it is your day to clear everything up and to let the court know, well, this may be not the full truth, or this may be something that was said incorrectly. But as you sat there, you're not taking accountability. You just say, it was just text messaging. Okay, that's all I did. I was trying to, make everything better, and I was trying to, make peace with the victim, knowing it violated the law.
Yes.
Yes, and you know that.
I do. Yes.
And you keep interrupting, and that means this is going to be the longer it's going to take. But you fully knew that, and you comprehended that, and you understand that. And yet you continue to do that. You continue to violate the law. You continue to put on a dumb face. You continue to say things where the court should think that you don't really understand. And just to the best of what I can understand, I don't believe it again. I don't believe it. You fully understood every single thing you were doing, and you continued to violate the law time after time after time after time, and with every excuse. And then you're sitting there not taking accountability, not being responsible, trying to just kind of haphazardly say, well, I was texting and it violated. And then you victim blamed. You said it was her. It was her. It was her. She's the one that hurt me. She's the one that beat me. She's the one that did this to me. She's the one. I don't have any alcohol issues. I don't have any drug issues. I don't have any violence issues. I've never engaged in any domestic abuse. I've never done this. I've never done that. It was always her.
I didn't say that.
Then what did you say?
It takes two to tango.
It takes two to tango. Sure does. You can talk to the domestic abuse, domestic violence counselors and all of that, and the lawyers and all of that involved, and the law enforcement officers and all that. It always takes two to tango.
It does.
Does not take two to tango. Does not. Even if she came at you, she whipped you with a extension cord, she beat you over the head with a bottle. Doesn't take two to tango. It takes your two legs to get up, to walk out of that door, and to stop.
I've done it many times.
And then to go deep, deep, deep. 911, what is your emergency?
I didn't want her to lose custody of her
on
son.
advice of counsel, I'm going to ask you to quit interrupting, Judge. Okay.
And I have to say that now too, because we are now at 12:28. This is a half an hour over. But again, I'm not cutting it short because I cannot. That's not my job. My job is to do this thoroughly. But again, I do have to say, I think I've heard everything, and I can't have you make any other statements because I have to sentence and we have to move on. I think that this is serious, and I think that you knowingly violated, you knew what you were doing, and I think that deserves punishment. Probation? Yeah, sure. What the court is going to do is I will follow a recommendation for probation because you need oversight. You need somebody to watch over you. You need somebody to make sure that you're not drinking. You need somebody to make sure you're entering in the programs that you need to enter into, because you're not, and you're doing things knowingly violating the law. So 1 year of probation. I'm going to order, because I think that this is so serious, and I think that you are dodging responsibility and accountability, 45 days of conditional jail to be remanded immediately after today's hearing, because it is that serious. I saw no accountability. I heard no remorse. I just saw the, what is it? The I'm rubber, you're glue, I'm the eraser, and it bounces off of me and sticks to you kind of deal.
It's not like that.
But that's what it's coming across as, okay?
But it's not like that, Your Honor.
Okay, I hear you. But that's the court's order. On probation, absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia, no alcohol, no bars, taverns, liquor stores, casinos, or establishments that have the primary purpose for the sale or the service of alcohol. I think I said absolute sobriety, but regular drug testing, substance testing, regular alcohol testing, immediate alcohol testing upon remand to the jail, and substance abuse. No contact with the victim's family, the victim's residence, or employment. I'm going to order a domestic violence program, not through restorative justice, a different program as determined by your Department of Corrections agent that must be accomplished and completed within the first 3 months of probation. AODA assessment and follow through. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I am ordering $443 in fines and fees. Payments will be at least $50 a month. Failing to pay not only means the court will enter a civil judgment against you, you're always going to owe it, but the court will issue a warrant. You could most likely sit jail as a sanction for failing to pay. I'm going to be very clear with you. You could sit up to 6 months in jail for fail to pay. If you cannot afford to pay, you must have a hearing with me. So I'm also going to order a total 9 months imposed but stayed sentence, not a withheld. So you have 45 days conditional jail, 9 months total sentence. Any jail credit, Mr. Rosenthal?
Could I have 48 hours to respond to the court on that? There may be a day or two, but I just need to look into it, Your Honor.
You do. You have 1 week to provide that to the court. Again, 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I need your DNA. The jail will make sure that we have that. With this, I don't believe you have the ability to request it be expunged through a written letter to the Department of Justice. You and your attorney can look to see if you have the ability. If you do, you can do so. If not, that's up to the Department of Justice. Mr. Vila, what am I missing?
Nothing, Your Honor.
Mr. Rosenthal?
I don't believe you're missing anything, Your Honor.
All right. If we're not missing anything, we are adjourned. Thank you.
This courtroom battle ended with a powerful message from the bench. Violating a court order is never just texting, when the law clearly says no contact. The judge made it clear that repeated excuses, shifting blame, and lack of accountability can heavily influence sentencing decisions. In the end, the defendant received probation, strict conditions, sobriety requirements, financial penalties, and immediate jail time, showing that courts take protective orders seriously. This case is a reminder that credibility matters, courtroom behavior matters, and responsibility matters. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.